Hi, everybody. Welcome to Trial Alchemy. And today I am delighted to have with me as my guest Jude Basile. Now, Jude probably doesn't need any introduction. He's been practicing law just about as long as I have, since 1982, and I only have a couple years on him, but he's had quite a career and a very impressive career. Jude has tried over to verdict over 100 jury trials, and he has been invited and is a member of the Inner Circle of Advocates, which is limited to just 100 members in the entire United States. In 2022, Jude had one of the top 5 verdicts in the state of California, top 25 nationally, and it was the highest jury verdict for a single wrongful death in California history. 7 times he's been named Trial Lawyer of the Year for various bar associations, including the Consumer Attorneys of San Diego. Jude started out in San Diego. And he's been an invited speaker and presenter to a lot of different trial lawyers organizations and trial colleges throughout the country. And he was very involved for many years in the Trial Lawyers College that Jerry Spence has run over many, many years. And so probably the most importantly, though, although he's still trying cases and consulting on cases, Jude likes to spend time traveling between homes that he's got in the Central Coast of California, Puget Sound in Washington, and South Shore of Hawaii, enjoying his family, which is certainly important to do. So Jude, welcome, and thank you for being a guest today. It's great to have you.
Well, thanks, Monty. It's nice to see you again.
So Jude, as we start, if you would, it would be great if you might share with us one of your most satisfying trial victories. Doesn't have to be the most, but just one you can think of that we can start out, you can share with the audience.
You know, I've been thinking about that because you told me to think about that before this, and there's more than one that comes to mind, but there's a common theme in all the satisfying trials I have, and that is the relationship that I developed with the people I represent. I mentioned your question to my wife last night, and after a long pause, she said, "What about all those Christmas cards we get?" And we still get Christmas cards from people I represented 30 years ago or more, with handwritten notes about their kids or my kids or something. So it's hard to pick one. And the most satisfying time, I think, is when I'm out in the hallway after a verdict and the jury's literally hugging the people I represent or myself when jurors do that. And a specific one that I can mention is I mentioned I represented this college kid that was renting a place out in San Diego State, and as college kids do, a little too much partying, I guess, and they started jumping around on a wall that came down on him, and he had a horrific lower body injury. It was terrible. I forget the name of the condition that happened, but they had to cut his veins from his groin to his ankle open in order to save the circulation because of a crush injury on his leg. But the moment that was satisfying in trial, or after closing argument, before we even had a verdict, we were walking back to the office, and he pulled out a storybook about my knight in shining armor. And his mom and dad and him gave it to me, and they said, "This is a book we used to read to him when he was just an infant, just a young kid, about finding his knight in shining armor, and you've been our knight in shining armor." And they gave me his young book, his book from when he was young that they used to read to him. And so those are the things that stick out for me. And another thing from that same trial, though, and it was a hard fought trial, and there was a really good lawyer, one of the few defense lawyers I've become friends with and gotten to know. And yeah, I'm sure you know him too, Dan White there
Oh
in
yeah,
Diego. A
very talented trial lawyer.
yeah, quite a formidable opponent, but
Yes,
it came out well. And the judge was Enright, the younger Enright,
the younger.
the younger Enright, and you know, a lot of judge gives lip service to the lawyers at the end of trial just to make everybody feel good. But Judge Enright, I felt, gave sincere compliments to both Dan and I, saying that he saw this case was tried at a very high level. So that case kind of sticks out with me, but it's representative of I think, and the lesson from it is, you know, it has to be more than the people you represent's case. It has to be your case. You have to be so into, this is just my way to practice. There's many ways, but you
Right.
have to be so intimately involved with the human condition and what they've been through that it becomes important to you. And so that's why so many of these are so touching. You know, another one of I might mention quickly was a woman who lost her only daughter in a case against the city of Escondido. And the ironic thing is, before her daughter was killed, she went into city council and said they need to put a light in at this intersection or else someone's going to get killed there.
Oh my goodness.
And we had that on tape, and it ended up being her daughter that was killed there. And even
Wow.
better, this was back in the days when email was just coming out. We found an email that the developer at the corner there was told by the city to put a light in, but he called the mayor, who used to be his boss at San Diego Gas and Electric, I think it was, and said, "Hey, is there anything you can do to nix this light in our development thing?" And the mayor like wrote to the city people putting it together and says, "If this is not a slam dunk health and safety issue, is there something we can do about this?" And they dropped the requirement for the light to go in, and then this
Oh
woman
my goodness.
killed.
Wow.
And it was her only daughter, and we got a good verdict, and it got overturned on appeal on an immunity issue.
Mm.
And the thing that has always stuck out to me, that was even before I have had kids, and my oldest is 26 now, is I said to her after that, I go, you know, Jean, the pain I've seen you go through in losing your daughter, I don't think I ever want to have kids and have to face that.
Mm.
And she said to me in an angry tone, she says, "Jude, if I'd known that's how you were going to feel, I would have never hired you to represent me. Even though I only had 17 years with Michelle, with my daughter, those are some of the best experiences I could ever have in life. So please have kids." So I've gone on and had 3 kids since that. So it just shows what these cases and trying them so closely with these people do to you. And those
Oh,
what sticks
they're
to me.
so important. Well, listen, I sadly I can understand what she went through. Uh, Over 35 years ago, my family lost my brother who was killed in a head-on car accident. And from going through that grief myself and watching my parents go through it, my belief is I think the hardest thing any human can experience is having a child and losing your child before you go. And but I agree with that mom. I think the thing we got to do is we got to cherish the time we had because nothing's guaranteed. And we got to really be thankful for the time that we had with that child or that brother or whatever it is. So I'm glad you represented her and I'm glad you care about your clients. And let's talk about this a little bit more. You're not the only person in the world who's a trial lawyer who does this, but you and others really take a lot of time to get to know your clients and how their, in your case, how their injury or the death has affected the family or the members and all that. And that's pretty darn important to do. And so talk a little bit about why you do that
Yeah.
and how you think it helps you get your results.
Well, I think the closer we can get to living their experience, the better advocates we're going to be.
Mm.
And in order to truly live their experience, because particularly if you have a very serious injury case, you know, a crushed leg or a paralysis or serious brain injury where their functions really been diminished. There's a lot of things going on there. And the number one thing that I think reason why I spend time, and I'll tell you how I get around to doing that, but is not just to intimately understand their loss and what they're going through, but it builds trust with them.
Mm.
It builds familiarity with each other. It builds a certain comfort level that when they see you, they're not all uptight like, oh my God, this is my lawyer and what this is going to be heavy shit and what am I going to think about and what doing, which I so often see when people wait till a month or so before trial and then they start trying to do that. It can be done, you know. That's what I want to say about the way I prepare stuff. There's other ways it can be successful too, although I haven't found them.
But we want to talk about your way, Jude. We know there are other ways. So
So,
your way we want to talk
so,
about.
so I can't remember, Monty. I can't remember the last time I signed a new client in my office. It's always been at their home or at a hospital, uh, or at their work, someplace in their life. Um, the family's work, like in this last one, was a terrible brain injury, and the mom was working, and we were at work. But so that's where it starts. You know, let them know that you can come to them, that they're not going to come into some fancy office and sit in a waiting room and talk to a receptionist and fill out some paperwork and, you know, look around at your plaques on your wall and wonder who's this big. They need to know who you are. Don't get me wrong. But,
Right.
and I always tell them that. I go, look, you can come into my office. I prefer coming to your home, though, to go over these papers and that. So, you know, I think you'll feel more comfortable. You don't have to dress up or get anything special from me. I just want to be there and with you, and it'll make it easier for you. You don't have to worry about coming here or there. You know, I'll come there. So that's where it starts. And usually that first meeting is 3 hours or more long, and
Mm.
absent, you know, them having commitments or something. But I block off, I'll have at least 3 hours blocked off with them. And of course, you know, you got to explain the fee agreement and all those legal things, which are important. But I kind of put that off till the end, actually, of this first meeting, you know, and it's almost the same thing as voir dire, you know. You want to get them talking, and you want to get them talking about things that matter to them in this case, you know. Uh, you know, how's the injured person or whoever it is, how are they doing? What are they doing? And I'm here because I just don't want to know what it's been like for you and your family since this has happened. I mean, I want to know that, and I'll see that with all the time we'll spend together. But I want to know, what was your life before this happened? You know, where did you grow up? Where did you live? Where did you go to school? Where did you work? What did you love to do? What did you hate to do? What gave you troubles in your life? What gave you happiness in your life? What was your hopes and dreams? I go, we're going to go through all those over time, not just all today. But I'm going to want to know these things. Now, it doesn't mean I'm going to go tell the world because you're the boss. This is all privileged between us. You're the boss. And if you tell me I don't want something out, I'm bound by that. I don't want something out. But
Yeah.
that's for down the road. So anyhow, Monty, you got me going like I'm trying to sign you up here, you know. But but
That's all right, though.
those are some of the ways I begin the representation. And so then I'm at their home, and then I think it's so important to do uh, things with them where it's hard to ever meet with them where you're not talking about the case. That's
Right.
it always comes up to some extent. But so it's important to plan things that'll do other things with them. You
Do
know,
other things. Yeah.
I've been to I know this one family. It was a cop case in San Diego, and a young Mexican kid. Well, at the time, they told me the verdict was the paper written in the paper. The San Diego Police Department said it was the largest uh, police verdict against them in their history. I think there's been bigger ones since then. It was about, I think, 12 or $15 million, but it was a Spanish speaking family. They spoke English too, but mainly Spanish. And they went to a little Spanish speaking Catholic church down in Southeast San Diego.
Okay.
And so, you know, I got to, and they were very spiritual, very religious. They prayed a lot when I came to their house. They had a lot of religious things in their house and all that. And I got them talking about their church. So I went to church with them. You know, I went to church with them on a Sunday, and tried to communicate my best with their friends that they introduced me to, and I met, and then you know, from that, then you can find other people that can help your case, other witnesses. And these other witnesses, this is what I was saying in the beginning, when you develop that trust relationship, when you're seeing the people you represent regularly, and they start to trust you, and you know, they come over, uh, and you're visiting there, and they feel good, and they invite you to dinner. Then the next thing you know, they're saying, come over for dinner. We love to cook. And next thing you know, you're there for dinner at their house, and they start to trust you. And then when you're talking to their friends that you may use as witnesses, it, you're getting a open door from them. You know, they're going to tell their friends, hey, my lawyer wants to talk to you. He's a great guy. He's a good guy. You don't have to worry. He's dresses like us. He's calm, you know, or whatever, you know. When
Right.
you have that relationship, then it kind of spreads to potential other witnesses to meet them in their life, and they lay the groundwork of trust, you know, and it's easier to talk to. And again, all this is done outside my office.
Right.
I don't bring people. I will bring people into a conference room and kind of mock play a little bit of depot stuff so they feel comfortable sitting in a conference room office and stuff like that. But that is never my primary meeting place, nor with witnesses either.
Right. So
So
I'm hearing
I
you.
do it to build up the trust. I do it to build up how much this case, how important it is to them. It becomes very important to me. And there's a downside to this, though, too, Monty, or
Yeah.
as lawyers like to say, a caveat to getting close to the people you represent. And that is when it comes time for trial, you're all jacked up and you're all fired up emotionally, and you want to do well, and you're going to kick their ass, and you're jacked up and all that. And the area to be careful is, you know, what you've gone through in this story for the past 3, 4, 5 years to get to trial. You know all that. You know
Right.
what's been done to them in depositions, and how they've been jerked around by defense medicals, and how you've been hit with summary judgment motions, and how you just went through 35 in limine motions and all that shit. And now you finally get a chance to talk to a jury, and so you're all jacked up and want to do it. That's where the thing you got to, whoa, stop, and remember, you can't get ahead of the jury.
Yeah. The
There's
jury's new to it. You can't get ahead of them.
You can't. So if you come in there all passionate and fired up and jacked up right away, they're going to go, whoa, whoa, what's this? I haven't heard anything. Like, and I think the realization of that has evolved over time. I mean,
Yeah.
back when we first started, Monty, I think in the 80s, it was like the beginning of opening statements were all focused on the tragedy,
Yep.
on I heard a great lawyer in San Diego came to me one time and couldn't understand why he either lost or got a low uh, verdict on a wrongful death of a child case. And he told me, I don't understand how I did this, Jude. Everyone was crying at the end of opening statement. At the end of my opening statement, there wasn't a dry eye in the courtroom. I go, well, how'd you do it? He says, I stood up and I started with a picture of the tombstone. And I
Yeah.
said, if you were to go to this graveyard on a any Tuesday afternoon at 2 in the afternoon, you'll see a lady with a bouquet of flowers in her hands, sitting on a bench with tears rolling down her cheek. And that's the mother of this girl that died, this thing like that. And that's how it started off, the trial. And we know now, like we should have known back then, the focus has to be on the wrongdoer at the
Yeah.
beginning of the case. The focus, as much as you can throughout the case, focus on the wrongdoer, on the wrongdoing, on that. And I've become an advocate of not having the people we represent there for much of the trial. Keep them away because, I've come to a point where I'm very comfortable with that because I explained to the jury, folks, this is probably again in very serious or wrongful death cases. I tell them that this family's been through this terrible tragedy for 3 or 4 years. So I don't want them here to have to go through it yet again. Listening to what happened, listening to the police officers, listening to the accident reconstructionists, listening to the safety people, they know it all. They've been through it all and seen it. I just don't want them to sit here and go through it again. So I'm not going to have them here except when they testify, and you met them before we started voir dire. They're going to be here to testify, and at that time, you'll see them maybe for closing. But what I want to say is, don't hold that against them that they're not here. If you're going to hold it against anybody, hold it against me, because
Yeah.
that's been my call. So with
Yeah.
that
So
explanation, I mean, they're usually nodding like you just were there when you tell them that, yeah, I get it. I understand. Yeah, I don't want to be here and looking at these photographs and these x-rays and these medical exhibits of how bad this, and people saying how horrific, and the life care plan. And I mean, it's just crazy, to have them there for that. And the other thing, back to focus the attention on the defendant. I tell them this, remember, this trial is not just taking place inside this courtroom. This trial is taking place every minute from here on, no matter where you're at. There's jurors around, there's bailiff around, there's people, but mainly jurors around, and they're going to be watching you every moment. Whether you're in the courtroom, they're going to be watching you, or out of the courtroom, they're going to be watching you and where you're at and what you're doing. And that's why before I start a trial, I'll go the week before, and I'm never trying cases in the same courthouse anymore. It seems they're all over somewhere, but but I'll go there the week before. I'll go there the month before and go to the jury room and go in and talk to the jury commissioner when no one's around, and I'll say hi. I'll introduce myself and tell them, hey, I got a trial coming up in a month from now, and I'm not from this area, so I wanted to just stop in and see, how you guys orient jurors. What do you do, and what do you think? And they like open up. They go, wow. Most of the time they go, wow, no one's ever done this before. That's pretty neat. Where are you from? Oh, it's San Luis
yeah.
Obispo. So then they go, well, we do orientations on Tuesdays and Thursdays, and we play a video for them, and a judge comes and talks to them, and we hand out these little pamphlets, and that's it. And, and I go, great. I goes, can I come on Tuesday and watch an orientation? My trial's not, it's a month off, so it's not like I'm going to see any of these people again.
Right.
It's all right if oh, you want to come to an orientation? What we do? Yeah, I do. You're welcome. So I'll show up at an orientation and see what they go through, and I'll get the pamphlet that they hand out, or I'll get the sheet of papers where they tell them where to park and where to have lunch, and oftentimes when I stand up, the first thing I might say or do, or certainly throughout the jury selection or the mini opening, I'll grab that brochure that's down there in the courtroom to empower them. I go, hey, I was down there in that jury room and I saw this brochure, and, it said how important jury trials are and how you're the conscience of the community right here in this pamphlet that they handed out to you down there, And so now you're starting to build familiarity with the jurors. They're like, wow,
Right.
this guy knows that he went through what I did, and all that. So I go through that. And then the other thing I do, that I was about to handle how trials go on outside the courtroom, but I'll go there the week before and I'll know, okay, we're going to be in department 68 and it's on the 4th floor. Well, I'll find a spot on the 5th floor or the 6th floor or down the hallway, whatever is available to get out of sight. And I'll take the people I represent, usually that same week when I'm there, and I'll show them this spot, and it's out of where no one's going to sit, the floor upstairs, the floor downstairs. And so then I always tell them when we're on breaks, if you need to go to the restroom or whatever, but that's where we're going to meet. And that's where you use those restrooms up there, and we're going to meet up there, and then we can talk. And then, not that you're doing anything nefarious, but I love it when the defense lawyers just hang out around the jurors, because the jurors are a little nervous with all these guys in black suits and shit standing
Oh,
around.
yeah.
And then they're like whispering in each other's ear and talking and going like that. What's the jury think when they're seeing that, and then we're not even around, it's no big deal, but they're watching them. So those are two things I do before trial. And
That's great.
it eases the anxiety when you have that meeting spot, like where,
Oh, yeah.
with my co-counsel or my paralegal or people there, everybody knows like that's where we're going to
Yeah.
be on all
That's
recess and breaks, So
that's very smart. So you're doing stuff that a lot of lawyers don't do, and it's all good stuff. Now, one thing I'm hearing consistently from you, Jude, and it makes sense, trust. You got to build trust first with your client and their family and friends. And then when you get to the courthouse, you're building trust with the jury when you get into the voir dire and all that. So let's go and let me just ask you a broad question at this point. We've been talking about some of the ways you prepare. There's a lot of aspects to trial, as you know. You've tried a lot of cases. But when you think about it, what do you think is the most important part of the trial in a jury trial? And why?
Yeah. I think the most important part of a jury trial is jury selection.
Okay.
You certainly have to get the right jurors,
Right.
but more importantly, I think you have to start building that trust. And I practice voir dire a lot. I practice voir dire with every focus group I do. How you deal with the dynamics of group formation, which is probably a better name for jury selection or group formation or group division. Sometimes
Yeah.
I think the defense is just wants to get a bunch of people that hate each other on the jury. Those are best defense juries, I guess. But building trust in voir dire, I think, is very important. And probably the other part of trial that's comes in second, because I believe jury selection's first. Second is cross-examination. The
Okay.
jury wants to, because it's an opportunity once again to develop credibility. It's an opportunity to tell the story through your story through defense witnesses.
Right.
That so and if they've really hurt you, they've really hurt you, you got to deal with that. Sometimes if they've really hurt you, the best way to deal with it might be no questions. you know,
Exactly.
you know,
Sometimes you shouldn't ask many
it,
or
yeah,
any.
the cardinal sin of cross-examination, I think, is unless you're really good and can really set it up right, is to just rehash direct. I see that often, people will just
That's
do,
totally bad.
and and these paid experts, are been there, more times than most of us. They've been in court, and uh, they know how to like be evasive, and you can use that in crossing, but you got to prepare cross-examination. You're not taking it down, drawing a line down your yellow pad and taking notes while the guy's testifying, like I used to
You got
see.
to prepare that ahead of time.
Yeah. But
Yeah.
back to this trust thing, something I want to say is trust comes from likability, not phony likability. You got to be real, but uh,
Yeah.
it starts when I walk into the courtroom, and I also will get to the courtroom the week before to look out to check sight lines. Where am I going to put my easel up? Where is the big screen? And then
Right.
I will sit in each juror's seat, each one. I'll sit there and look, okay, where is it? You get permission from the clerk when no one's around, and you can sit in each seat and you look at where your demonstratives are going to be, and you look where the witness is, what angle they're going to see the witness, and especially us, because we sit closest to them, you look at what their view is going to be of you,
Yeah.
of your desk sitting there. And so I do all that, and then when I walk in, I will have, and I think this is pretty much standard now. I hope it is at least. I will have a witness list with the names of my witnesses, and I'll go over to the court reporter, and
Right.
now we got to hire our own court reporter, so this isn't so important anymore. But we
Right.
have our own that they know us. But I give them here's a list of witnesses. Here's their names. Here's the spellings. Here we're doing, and they go, oh, thank you, thank you, thank you. Here's the spellings. Here's everything on the witness. And if you have some crazy medical term that's going to come in, you have 4 or 5 of them. You say, here's some terms, and they'll go, oh yeah, I've heard that one. And so
Right.
you go, wow, thanks. And then I say, look, if I'm talking too soft or too loud or too fast, please don't hesitate to stop me and say, hey, Jude, slow down or whatever when you're doing it. Please do that. So I do that little discourse with the court reporter, and I'm doing it the same with the clerk, But what's funny is how lawyers are always buttering everybody up at the beginning. Everybody's doing it. So I try not to put too much butter or honey on the whole thing. I just want to be real, but let them know I'm there. I'll go to the clerk. Hey, do you want checks every day for the jurors, or once a week, or how's that going? Any way I can make your life easier? The exhibits are all pre-marked and they're here, and we got it on a thumb drive too, and just show them you got all your shit together.
No, that's good. Let's go back to the voir dire that's so important, jury selection. What are your goals in voir dire and how do you accomplish them?
Yeah. Well, my goal in voir dire is two pretty simplistic goals. And then there's a third, which is up there important. And that the third, I'm going to start with that. You got to find the bad apples. You got to find
Yep.
the ones that are out to get you, you think. And it's hard to do. It's sometimes better to have, it's always better to have multiple eyes there watching reactions and taking notes and
Right.
all to find, what you think. But that's the third goal of mine. My first goal is to start empowerment right there with jury selection. And by empowerment, letting them know about the case, about how important this case is, about how important it is for a jury to decide this case, about how that's so special because it's only done We're the only place with civil jury trials in the world, as far as I know. And it's so important, you know. So my first goal, and the case is interesting. This is an interesting case that you want to be involved in. That's my first goal. If I can get this panel going, holy shit, this is big stuff. This is interesting. You know, I want to be part of this, you know, for the right reason. While I'm going to make these decisions. I'm going to be part of this community, part of this group that's going to make such important decisions. We're going to be talking about the value of life and love and relationships between husband and wife and parent and child, the value of those. We go, wow, I don't know how that's done, but I want to be involved. This is interesting. So the first goal is, this is interesting. I want to be involved. And then the second goal I have is, if during the voir dire process, I shouldn't say if, but hopefully during the voir dire process, when I sit down, I have established them at least going, you know, I don't know any lawyers in my life, but the lawyers that I have seen on TV that show Suits or something that's out, you know, they seem like arrogant, rich guys that know-it-alls and all that. But this guy seems a little different. And I'm not sure or convinced just yet, but I think I might be able to trust this guy. So, Monty, those are my two goals. One, I'm interested in this case. I want to be involved. And hey, I think I might be able to trust this guy. Those are two most important. I know there's so much taught on jury selection and what to ask. And, you know, everybody's looking for those trick questions. I saw someone post the other day that the very most important question is, if this happened to you, would you file a lawsuit? You know, I think, well, that's probably a good question, I guess, you know.
But you gotta get them talking. You
Yeah,
gotta get
how do I
them.
do it?
You
Yeah,
gotta get them to trust you,
yeah,
or think they maybe can trust you, right?
right, right. And so those are my goals. The steps in voir dire, that these are simple steps, um, are: one, get them talking; two, get them talking about things that matter in the case, things
Yeah.
that matter in the case. If there's a big comparative negligence issue, get them talking about that. If you know, you're going to be asking for a large non-economic damage amount, get that out there and get talking about it. If you know, your guy had a few drinks, some line of cocaine and marijuana in his system while he was speeding on a motorcycle. I had a case like that once.
Yeah, you
Uh,
gotta talk about those bad facts, don't you?
you gotta, the sooner you can get them out, the better, because that's doing a lot of stuff for you. That does a lot.
Yeah.
I mean, that bad stuff does a lot of stuff for you. It gives you credibility. It lets them see you're not afraid, that those are things that you're not going to hide, you know. And you could even say that, you know, there's some things I need to talk to you about because you're going to hear it in this case. And when I first heard them, it scared me, and they're not good. And then as you're going to hear that Scott had a 0.12 blood alcohol. Who here, that's all you need to hear. I mean, some of us, you know, that's all I need to hear. If he was a 0.12, that's 50% over the legal limit. I'm done. I mean, I understand that. Somebody must feel that way. See how you coaxing out of them? You know,
Yeah.
point in my life, I felt that way too. You got what's coming, right? Don't you feel that way? You got what's coming. And then someone will start disagreeing with you. No, well, why? Well, I don't know what else. There must be something else here. Well, what else do you think? Well, maybe the other guy did something wrong. Yeah, that's right. Okay. So you get the bad facts out. And the other thing that I look for is a personal story that I can get them to share and relate with. Uh,
Mm.
on a
Out of the juror.
Yeah, right.
Okay.
And like, well, for example, wrongful death case are the easiest but hardest ones to do both. And by that, I mean, they're the easiest when you say, this is a wrongful death case. Note how I said that.
Yeah.
You don't say it's a wrongful death case. This is a wrongful death case. That's what it's, wrongful death case. So, I need to ask you some questions about death and losing loved ones. But I want to tell you up front, if somebody doesn't want to talk about that stuff, just let me know, and we won't talk about it. But I do need to ask some questions. Who here has lost a loved one, or in a situation where soon to lose a loved one? And I've had several, well, many almost, responses to that. And one was a woman raised her hand then and says, this is what I mean about the personal story connection. So a woman raised her hand and said, I had a 2-year-old son, and he was playing in the driveway, and his grandfather, my dad, came driving in the driveway and didn't see him.
Oh,
Hit him and killed him, my 2-year-old son. Well, what do you do with that? I mean, one way is, oh, ma'am, I'm so sorry to hear that. I'm very sorry to hear that. Do you think you'll be able to put that out of your mind and just judge this case on the facts and evidence that you hear in this courtroom? Makes me want to puke when I see someone
yeah.
do that. Because did you see your reaction? Well, I could see it. You probably, I don't know if you saw it, Monty, but whenever that lady told her story of her father running over her 2-year-old and that, everybody went silent and just put their head on my, like, you could just see, I can't think of anything worse. Everybody was. And so what you do in that moment is stop and take that in. And then I probably said something back to her, like,
But
well,
let's wait. Stop and take it in as you give some silence for a little bit, right?
silence is perhaps the most powerful thing in a courtroom.
Yeah.
And it is not used enough. It's not used enough. You have to use it regularly in your talk. So when she said that, I like took it all in and felt it and said to her, oh my God, I said, I don't know how anyone can deal with that. And I'm lost. I don't know what to say other than I'm sorry to you. Counsel, get over here at sidebar. That's what happened. The judge screamed at me and said, get over here at sidebar. So he drags me to sidebar with defense counsel, and he says, listen, move on. I don't want any more talking about this to that woman. She told you she lost the child. I don't want any more. I don't like what you're doing. So stop and move on. Now get out there. Okay. Walk out. Now what's going to happen if I just start talking to someone else about something totally different?
Not good.
The jury's going to say, who is this asshole?
Yeah.
But what if I start talking to her and keep disobeying the judge? I'm in a catch-22, aren't I? I mean, what am I going to do? So I went out and I looked at her, and I'm taking my own feelings in. And I said, ma'am, I wish I could talk to you more about this, but he just told me I can't.
Perfect. Yeah.
He just told me I can't. So I'm really sorry. He told me I needed to move on. counsel, get over. Don't you ever tell the jury what I told you, and then shoot my ass out again. And so that's where the whole shift began. I was now part of that jury, and this was a mean judge that's coming down on their ass, coming down on. They wanted me to do something to help this lady. I was trying to help this lady or talk to her, and this
Yeah.
guy in robes like being a prick. He was also the judge that told me I could not look at the jury during cross-examination.
Oh my goodness.
He said, "Mr. Basile, I don't want you looking at that jury anymore during your cross-examination." Because I was essentially doing my closing argument with looking at the jury. He says, you no more looking at the jury. So I put up an easel with a big board that blocked his view of me and kept going.
So, Jude, one of the developments that wasn't there when we started trying cases, but it's been there in recent years, is the mini opening. And do you like the mini opening, and do you find that to be helpful for you in connecting with that jury and starting to get them to understand about your case?
I think it's the best change in other than the audio visual stuff that's come on now, the
Yeah,
animations that can
yeah,
be done, the demonstrative evidence. I'd say that a mini opening is the biggest beneficial change in trying cases in the past 20 years or so. So I really like it. It's really good. I can't believe that judges and defense lawyers now fight and don't want to do them, at least in trials I've done recently. They object, we don't want no mini opening. We just want the statement of the case, and that's it. So the jury doesn't know anything about anything or what to talk about or what's important or what's going on.
yeah,
And I say, Judge, how many minutes do you want to give me? 2, 3? I can live with 2 or 3 minutes if that's all that they're doing, 2 to 3,
yeah,
5 would be
yeah. They're
nice.
short.
Yeah, I mean it's fine, you know. Uh,
So let's say you picked your jury, you went through the voir dire, and you've created that trust. You've got them motivated, and they're empowered, and they're ready to go. And you've given them your your mini opening. Then what's your approach when you're giving them the opening statement? Tell them the whole story for the first time.
yeah. Uh, Number one rule is always keep them engaged, you know. I mean, that's your number one goal as a trial lawyer. Is I've heard someone tell me once, your job as a trial lawyer is to entertain that jury. Don't be a clown and goofing off and stuff like that, but you got to keep them engaged and interested. And if someone's nodding off or not paying attention or not there, you got to wake them up or do something or see what's going on or
Yep.
where are they or whatever. So the number one thing is you got to have an engaging presentation throughout the trial, but in particularly in opening statement. In complex cases, an opening that, like many of the things I do in trial, I've stolen from other people.
Sure. We all do.
Yeah, and the inner circle has been quite amazing to me now. I think I've been in it about 11 or 12 years, but the thing in complex cases to come out of the chute with that I found so interesting is you say, folks, at the end of this case, you're going to know more about safety at high pressure gas power plants than most people in the whole state of California. But with that knowledge comes a responsibility to hold the people that you find responsible fully accountable for all the harm they caused.
Mm.
So that I started out with that because it was the complexities of the power plant are going to be complex and can be confusing and shit like that. So I wanted to empower them. You're going to know more than everybody else in the state, but with that knowledge is going to come a responsibility to decide whether or not to hold these people responsible for all the harm they've created.
Yeah.
So now that kind of sparks interest, and
Sure.
then I go into the story from there, of who the defendant is and what their promises they made and how, in sticking with that same case, it was, slides of their website saying we are the largest high pressure gas plant in the world. This plant is in the world, and we provide safe energy. That's what they said. Here's what it is. So I started with
Out there
that.
on the website. And
Yeah.
this is the one out in Palm Springs, Palm
Yeah.
Desert.
Yeah. It was in Palm
So
Springs.
you got
Still
the
on.
150 million verdict?
Yeah.
Yeah.
So anyhow, if you want it, that was all non-economic damages, and that kind of ties into, how did I introduce that in voir dire? I introduced it in voir dire. The judge would not let me say $150 million, but he did let me say tens of millions. He says,
Okay.
we'll be asking for tens of millions of dollars. But how I did that, or how the jury understood it, I think, and came around to it, was I represented the widow and an adult son that lost their father and husband, who was
Yep.
44 years old.
Pretty young.
Yeah, retired Navy, 25 years or 28 years in the Navy, 3 more than what you needed for retirement. But in voir dire, when we got to damages, I said, you're going to be putting a value on all the harm that was caused as a result of the death of Daniel. And you're going to put a price on 2 very important relationships that have been taken away. And that is between a husband and wife, life partners, and the relationship between a parent and child. You're going to be putting a price on those 2 relationships. And before we talk about how you do that, I just want to know, how do you feel about having to do that if you're on this jury? And you get the bland question, well, I don't know how I'll do it, but I'll follow the law as the judge instructs. And, that's usually
Yeah.
the thing that comes out. And I don't know if you're getting anything there. So what I went after then, how do you feel about doing it? And if you get some of those, I said, can anybody think of anything more valuable in life than those 2 relationships, husband and wife and parent and child? Can anybody think of anything more valuable in life than that? Oh, it's quiet. Nobody's putting their hand up. I guess we can't. How about, and some guy put his hand up and said, I don't know if this was at trial or one of the focus groups that I did voir dire on, said, well, what about your health? If you don't have good health, you're not going to enjoy those relationships or have them, so isn't health more important than those relationships? And I said, hey, that's a good point. I appreciate you sharing that. What do you folks think about what he said? Immediately, 2 or 3 put up their hand and they go, well, what's good your health if you don't have those relationships?
Yeah.
That isn't that why you have good health, so that you can enjoy the people you love and around, and it all came from the group. It was beautiful like that.
Yeah.
So it's there, like, holy shit. I go, I'm telling you now, we're gonna be asking, and it's going to be your choice, not mine. It's your job on how much those 2 relationships are worth. But I just want to give you a feel for it. It'll be tens of millions of dollars each. for each. You know, what do you think? Well, you're gonna have to prove it. Yeah, don't worry about that. We'll prove it.
There you go.
Yeah, so
So you got it out even with the judge's limitation on what you could say.
yeah, right. That's such I mean, we got a lot of battles to do. I mean, I think for the most part, judges really try to do their best and do a good job, and they're certainly overworked and underpaid, and most of them are shitty lawyers. Or wait, I didn't mean that. I mean, why else would you want to become a judge? You know, I don't mean that. There's some really, really good judges that have helped me a lot. I don't mean in my cases, but just helped me. And I could start naming them, but then I'll leave off ones that I should put on there. You know, just
Well,
to
you've
me.
already named one who's a great example, and that's the young Enright in San Diego. And what a great judge.
Yeah,
What a great service he's provided over the years. And that's the kind of judge you hope to get
yeah.
if
Kevin
you're going to
Enright
try a case.
is
Yeah,
great,
Kevin Enright's a great judge, great guy. Well,
and he had a great mentor, his dad. I
oh
had
yeah, his
I've
dad
tried.
was a phenomenal lawyer and judge. So let
Yeah,
me ask you this. We've talked about voir dire, mini openings, opening statement a little bit, and you've also said, hey, voir dire and cross are important. So on the cross, a lot of lawyers just kind of they're limited to what they do in cross to just the old classic way that most lawyers in law school are trained to go, hey, ask a closed question, only ask for a yes and no, don't do anything else, control the witness. And you worked a lot with Jerry Spence over the years with his Trial Lawyers College, and he did what I would call the open cross, or maybe, in a lot of his trials where he's not trying to have a closed cross. He would be very effective in asking questions, telling a story, and really not really caring that much what the witness said. Do you use both methods in your cross? Do you use one or the other? What do you do?
well, it's all case specific, you know that,
Yep.
Mark. But in general, my general rule is, what story are you telling with this witness? What
Right.
story do you want to tell? And there's two sides to that coin, or two choices of preparation there. And one is it the story of the witness, of who this person is and what they do, or who this person is, who they work for, how much money they make, how they just
Right.
testify for the defense, how they've represented corporate America their whole life, how they, get paid all this money, and who they are. And they got 3 kids and a lot of kids in college, and you got to pay for that. So you keep doing this, and it doesn't make you feel good doing this sometimes. And you just go on. The story is, who are they? That's
Yeah.
your boss. Who are they? And then the other story, you can either tell us, or both. The first one is who this witness is, and the second story, in no particular order, is what they did or what they didn't do.
Right.
So that's my general framework. What story do you want to tell with this witness, and what chapters of those stories do you want to do? I have it all prepared ahead of time. Particularly if you have lay witnesses that you got that were deposed, and you got key admissions they made in your deposition, and now all once at trial,
Yep.
they're going to go sideways on you. And that so for that example, this will be something easy to share with everybody, I hope. So let's say you got a deposition of some lay witness you took, and in that deposition, there's like 5 or 6 things they say that are very helpful to you, very helpful. Like, I think he was going 50 miles an hour, or I saw your client screaming in pain after the collision, or there's like 5 or 6 things that are really good that they've already said.
Right.
So you just put them in order and you like read it to them. You don't hold up the deposition yet or anything. You say, now, Mr. McIntyre, you agree that John was screaming in pain at the site of this crash, don't you?
I
Well,
do.
well, not really. Not really. I don't remember and all that. And so you got your 5 or 6 things page and lined out or more with experts that you know they got to admit and you got it done and it's got it there. And the other thing that I see most
Well,
often,
let me ask about that. So you got your 5 or 6 points you want to make. I love using video clips to do that cross
yeah,
impeachment because I think it's more effective than showing the
absolutely.
transcript.
Even better, even better.
Yeah.
But
Okay.
there's a little preface to that I've learned this and it's often overlooked. You don't have to do it for every witness that you're going to impeach with a video clip or the transcript. Video clips are
Right.
much better. You
Right.
don't need to do this, but this I'm referring to is uh, normally it is. Do you remember having your deposition taken? Yes. And you took a and swore under oath, didn't you? Yeah. And you told the truth then, didn't you? You know, and you get in there. Okay, let's read what you said. You know, that's you can do it that way, and I might, but I always the first time I'm going to do that in a trial, I want the jury to have the whole picture.
Yeah.
Remember, I took your deposition in this, yeah. And before your deposition, you went to your lawyer's office, right? And you spent time there preparing for the deposition, yes. And he went over all the rules of a objection, attorney-client privilege. Well, you were instructed on what was going to happen, right? And before I started your deposition, I said, if you ever want to take a break and talk to your lawyer, let me know, right? And uh, I go through all that. You received a notice and you knew this deposition was coming up for like 30 days before you even showed up, and you met with your lawyer and you prepared and you knew everything. And then I gave you a chance to that. And so like, you're like locking them in like, holy shit. Yeah, I was in a deposition, all that. So I lay out that whole scene coming, especially if you have a really juicy one that you're going to
Yeah.
get. You
Right.
lay out that they did all this preparation, all this thing, and now they come to trial and do that. And the thing is, and I think this is more the art. If you get them then and you play it, just be quiet for a second,
Yep.
and then just move on. Because I've seen lawyers and they try to beat them over the head with it, and then they can slip away, or you look like the bully or whatever, you know. So that's the
I
thing,
agree. You just play that clip and you're quiet and you move on.
right? You let them. You might look at the jury while they're watching the clip, saying,
Yeah. You let it sink in.
right,
So let's talk about this. You know, it's these things go too fast, Jude, and it's
yeah,
I've had so much fun, but we're gonna have to wrap it up fairly quickly. So um, you're doing your great cross, you get to the end of the case. Now we all know closing arguments are important, but we talked about this a little bit before we started the interview today, and that is you're not necessarily going to win your case in your closing argument, are you?
uh, Spence once told me that you can't win your case in closing. You can only lose it in closing.
Yeah.
You can't win it. So, yeah. And I think closings are overrated to a lot of extent. Overrated in the fact that that's what other lawyers always want to come see. You know, I want to.
Yeah.
When are you closing? They said, "Oh, I'm in trial. When are you closing? I want to come see closing." They want to see it because that's when you really get to empower and have fun and be passionate and go all out. But
Right.
which I think are all important to do. But closing for me is two things. One, showing them how to do their job. You got to take them through the verdict form. You got to do
Yeah.
like I often like to do a live deliberation, you know, and it's arming your favorable juries. Like someone's going to say, and you parrot some defense thing that they're doing, going to say blah 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 blah. When you hear that, think of da, 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 and so you do like that. And then each question of the verdict form, you do it on and write in how to make them answer and everything. And same way gone through damages. And
Yep.
so you got to show them what to do, help them. You're helping them. You're that trusted
Right.
guide. Let me show you, this is your job. This is what you're going to have to do. Let me go through what you're going to do. And I love it when I see them, when I say something like that and their notebooks open up and they take out a
And they're
pen,
writing notes. Yeah.
notes at that point, especially when you're putting your numbers up there. Although that's an overrated thing. I think, we used to be explained like, you see them all writing down those numbers. You see them all. Yeah, but so what? They're writing down the numbers so they can remember to scream about them in the jury room sometimes. I don't
That
know.
could
That
happen.
might be overrated. So, but that you're helping them, and then the second thing, empowering them. You got to really send them out like it's a football team taking the field, man. Like they're ready to go. We're going to do this, and we're going to do it right. And I can't wait to get in there and do it. So uh, that's a that's a thing. The other thing that I learned from that verdict in Palm Springs was I presented that to the jury by giving them a choice of the least amount and a just amount. I said
Ah,
the least amount in this case, after I went through it, and we don't have time to explain how it went down, but
yeah.
I said the least amount, you had 32-year life expectancy. Least amount is $1 million a year, 32 for the wife, 32 for the son, each of them, $64 million. But that's the least amount. Your job is to come up with a just amount. So instead of 64 million, they came up with 150 million when I said that. And that's hopefully working well on the appeal, because they tried to say the first thing the reason it's an excessive verdict is because the jury gave him more than he asked for.
Well,
No,
that's not true. Yeah.
that's not true. Yeah, my appellate lawyer wrote back that, wait a minute, look at the transcript. He said that's the least amount, and it was their number. You guys come up with a just amount. So
Yeah.
So at least and just thing was something I came up with, is just new for me that I could pass along.
I think that was a good idea you came up with. I like that. I think that's great. So Jude, let me ask you this, and we're going to close up after this, but this has been so much fun. Thanks for being such a great guest. So you've tried over 100 trials. I've tried lots of trials, but what advice would you give? Maybe it's advice you got when you were starting out. Maybe it's what you've learned along the way. But if there was somebody in the early part of their practice and they're saying, "Hey, Jude, what do I need to work on to try to become a good trial lawyer representing people?" What's your advice?
I've been thinking about that, and um, a person that helped me early on, and you'll probably remember him, but probably not many people hearing this or watching this will, but Earl Gilliam. Do you remember Earl?
Oh yeah.
Simply an icon in my eyes,
Yep.
as a person, as a judge, as a lawyer, as a caring person, and everything. And
Right.
I saw him in law school and also after law school when I was looking for work, and he got me on the court appointed panel in federal court. And he said something to the effect to me once, because I was saying, I really want to try cases. I want to do that. He says, well, good, you're on the right track, because to be a trial lawyer, you have to be a trial lawyer.
That's true.
And I didn't quite know what he meant at the time, but since then, I've learned that there's nothing that surpasses that experience in the courtroom. So, and in front of juries. So it's tougher though today than ever to do
Right.
that.
It's harder for folks to get to trial. Yeah.
I was a city attorney prosecuting one after another DUI trials for about 18 months, and that was great. And but you have to be a student of being a trial lawyer. I think that's the advice I'd give it. I know early on, even I'm continually to learn from listservs, I'll walk in and watch trials in the courtroom. I talked to Paul Rivera regularly, who's another icon of the trial practice. And I think my number one advice is try to get to trial on decent cases. Don't just try a case because
Right,
you try a case.
right.
Make sure it's something decent that you're going to do it. And make every day a learning experience. I would read Trial Magazine. I would read books on trial advocacy. I would read Osner and Dodd on cross-examination. I read constantly do something every day to learn what it takes to be a trial lawyer. And the other thing, truly care. Truly care. Don't just,
Yeah.
if you're in it just for the big verdicts and the money and how much money you can make, there's better ways to make money than this.
Well, you're absolutely right about learn all the time. I can remember the first 10 years or so in my practice. The only thing I read when I had free time was learning evidence, learning trial stuff, trying to be a better trial lawyer, listening to tapes back in the day about these great trial lawyers. You got to constantly learn and you got to be willing to go in there and all that. But you got to care, don't you? About your client first and foremost. And when you do the plaintiff's work like you do, that's one of the great benefits is you get to make a difference in somebody's life and help them through a terrible thing and at least try to help them when they need help and make a difference. Now you carry a big responsibility because you got all that weight on your back because you got to make sure you come through for them and you feel that, but you're helping somebody. You got to care about that. And that's priceless doing that work.
Yeah, very well put, Monty. Very well.
Hey, well, Jude, thanks so much for being such a caring advocate who cares about his clients, loves them, fights for them, and keeps doing it. Thanks for being such a great guest. This has been a delight. Thank you so much.
Great seeing you, Monty. Thank you.
Great to see you.